All right. All right. Here we are.
Are we back?
Yes, we're
We're back.
back.
Well, welcome back to
Happy
another edition
Friday.
of Live Feed Read. I'm Paul Reed, your host, and the Ed McMahon to my Johnny Carson, Jason Crawford, live from
You got it.
Tallahassee. We have a special guest today because we're going to be talking about
Yeah,
dogs. There's Millie.
Millie.
Well,
Oh, she's out, bro.
Millie's not excited
She's having my kind of day.
about Live Feed Read. So anyway, well, let's jump right into the
Well,
topic.
wait. Before we jump in, I have a question for you.
Shoot.
Are you feeling unburdened by what has been?
I can give her rats as it's over. I look, whatever happened, I was coming to work. Whatever happened, I was going to New York to party with Leanne and the Giants versus the Bucks game. Whatever happened, whatever, went to the Lightning game. So no, I'm not talking about
Nice.
that. No, if that's thank goodness that does not consume my ever breath or actually any breath. It's over. Hopefully,
Yeah,
God bless America. We move on. It's a
I
good place
think we're
to
all
live.
ready to be past
So I'm
the
not talking politics.
advertising.
All right, we're going to get back to
All right,
what
cool.
brought us here. And I was
Yeah.
reading, as I told everybody through TV land, these are the Florida Law Weeklies. They're appellate cases, and this is how good lawyers keep on top of the game because they read the cases because it changes the law and it lets you know what the law is, and they don't. It's like the mail, like Newman says, it doesn't stop.
You got a new message.
So here they are. So I was reading one, and it had to do with um, intentional infliction of emotional distress. And
Intentional. Okay.
that would be if someone does something to you intentionally and they cause you mental anguish, depression, things of that nature, anxiety, can you sue them? I mean, that's the tort. It's called intentional or negligent infliction of emotional distress. And that's what we're going to talk about as it relates to the injury or death to a dog.
Okay.
What was
Okay.
that?
You
You
had a
had your hand. I
case.
like that. You had your hand raised. This is good.
Yeah. You had a case a while back where the lady was driving and the guy behind her was honking and then, you know, it just ended up being a mayhem thing where the husband went and like ran through the gate and all that.
Oh
Is
yeah.
that included in stuff like that, or is
Well,
that mostly just focused on the property damage? Like, I guess what I'm asking is, help me understand the difference between when it's applicable, the emotional distress part versus property damage part.
that's fine. And in
Yeah.
most lawsuits, you have multiple counts. Count one on the case you're talking about would have been a battery
Okay.
or assault or battery. This one would have been assault because in that case, my client's husband put up a sign and basically says, "Watch your back. I'm going to get you or whatever," and that would be considered a
Okay.
threat. So there was a count
Okay.
one, which was assault. Count two was the destruction of property. Count three
Okay.
was the intentional infliction of emotional distress. So
Okay.
yeah, that was part
That
of
makes
the
sense.
lawsuit, and there
Okay.
were other counts I don't remember, but yeah, there's an
So
account.
it's a separate thing. Okay.
Right, it's a separate cause of action, a separate count within whatever happened.
And it still has the same burden of um, damages, proved damages,
Well,
and
in
proved
negligence, those
negligence, or
cases, it's uh, you just threw me off.
I'm
50
sorry.
in order to win, it's uh, the greater weight, 51%, you know.
Okay.
So it's not
Okay.
beyond a reasonable doubt like a criminal case. It's just, the greater weight of the evidence. Does it support that claim?
Okay.
All right. So here's what happened. This is a case Buchanan versus Miami-Dade County. So this happened obviously down in Miami.
There you
So
go.
let me just read. It says the appellant, the individual that won or lost, asked the court to decide whether, I'm just going to call him Buchanan, may seek damages for intentional infliction of emotional distress, which he says he suffered when a Miami-Dade County police officer shot and killed his dog, Sweetie.
Sweetie?
Sweetie.
Sweetie. Oof.
All right. Well, hold on. Hold
At
that.
least the dog
All
wasn't
right. So
named
that's the
Killer or
issue.
something.
So, and we'll go a little bit farther, but basically,
Right.
he files this lawsuit against the police officer in the county saying, I have suffered, mental anguish, for lack of a better description, emotional distress, because the police officer shot my dog and I should be compensated. You with me so
Okay.
far? Okay.
I am. Yep. Yeah.
Okay. So here's what happened, which, doesn't necessarily matter, but we're going to sit here and chat a bit. So while in flight from the police, meaning someone was running from the police, it was Buchanan's son. He jumped the fence, abutting Buchanan's property, ran into his home, closed the sliding glass door, but police officer was following him. He was chasing him.
So the son
Son
does that.
running
Okay.
from the cops, jumps
Okay.
the fence, runs
Yeah.
in the house.
Runs into the house. Okay.
Police
Got you.
officer chasing his son. Jumps
Yep.
the fence, and now he's in the yard.
In the yard. Okay.
Buchanan's
Past the
yard,
fence.
backyard.
Yep.
Well, guess
Yep.
what
Okay.
Sweetie
I'm
does?
with you.
Little Sweetie sees someone in yard and goes to
Yeah.
defend
Stranger
the
danger.
property. Yep. Oh, yeah. Oh, by the way, yes, Sweetie was a man eater. He was a pit bull.
Okay.
All right.
Well, that factors.
Well, regardless, most dogs, a lot of dogs would, you jumping in my backyard, they'll come and get you, which is
Yeah,
admirable.
but you're going to react differently to a Chihuahua versus a,
That's
American
fair.
Bulldog or something.
That's
So,
fair.
yeah,
So
I
anyway,
got you.
well, Sweetie evidently was somewhat aggressive because the officer caps him.
Like a right away. Yeah. Okay.
Well, it doesn't matter. I mean, I'm assuming it
Okay.
probably happened pretty quick. You jump the fence, pit bulldog runs at you, you shoot him twice. All right. Well,
Okay.
anyway, let's move on. That's
Okay.
what happened.
All right.
So
Those are the
now,
facts.
Buchanan is suing the police officer in the county for the intentional infliction of emotional distress because the police officer shot and killed his dog.
Mm-hmm.
All right. Those are the facts of the case, how it happened.
Mm-hmm.
Initially, right so far, I'd like to ask you,
Okay.
you think well, let me continue. The judge granted summary judgment for the police department,
Okay.
threw the case out.
Okay.
So now Buchanan is appealing, saying
Appeals.
under the
Okay.
law of the state of Florida, or as the law of the state is should be, the judge made a mistake, and I want you, the appellate court, to reinstate my lawsuit for what happened and for my damages, the intentional infliction of emotional distress. You with me so far?
Yeah. Yep.
What did the appellate court do, Jason?
I would assume they threw it out as well.
Well, remember that the trial court threw it out. They would either
Right.
uphold the trial court's decision, affirm it,
I got you.
or they would reverse it.
Okay. I think they would uphold the decision.
All right.
Um,
And why?
so I have like a million questions.
Well, we're not getting there yet because we're going to continue on with this case. I just want your initial thought.
So I think, not knowing any of the answers to those questions, I think that the officer is in the course of his own, in the course of duty, and if his reason there is legitimate, then he's not intentionally causing harm. He's in pursuant of his duties, and I would think that it's not negligence per se.
Okay, so
This is my quick snapshot. I don't have all the details, so
that's fine. The officer is chasing someone. He's following that person. You feel that he felt threatened. Possibly his life was threatened by a dog, and had the right to shoot it. And had the right to
now
shoot it.
whether I agree with all that or not, and I have all the details, I don't know. But I think that from a technical standpoint, like I think he's pursuing his duties, and in the line of his duties, I don't know that you can prove he's intentionally causing emotional distress and harm. So I think the intentional part is going to be problematic.
Well, guess what?
What?
the appellate courts don't have to worry about those types of arguments. They,
Okay.
they follow the law, and so let's just read it.
Okay.
I'm not saying you're right or wrong yet, but okay.
Okay.
So,
Yeah.
like you said, the court dismissed it, it granted summary judgment for the county and the police officer.
Right.
And what the officer in the county indicated was that the case should have been dismissed because Buchanan did not allege that he was present at the time of the complaint of conduct, meaning he didn't see it. He wasn't there when the police officer shot the dog.
Okay.
So that's really the issue in this case is on intentional infliction of emotional distress of an animal. Do you have to be present or not in order to prevail?
Interesting.
Okay, so I want to piecemeal it. So that was really the question, not whether or not the officer rightfully or wrongfully, because remember, those are fact issues that would be decided by a jury, not by the court. But the question as to whether or not the judge did the right thing or the wrong thing by dismissing it is, in order for intentional infliction of emotional distress for a dog,
do you have to be present?
Does the owner have to be there and witness it? And it could be yes, and it could be no.
Yeah, that's that line's thin. I think the answer is obviously yes if he's there, right? I mean, I don't mean the answer to that question is yes. I think that the harm is obvious if the person's there witnessing it. But if I arrive home and my dog is dead, I'm still upset, right?
So, so the question, the author's saying that he has to be present, and Buchanan responds with a case out there, Williams. It says on a different issue, but they try to link it and roll it into this one. Is that it was not necessary for him to have witnessed Sweetie being shot in order to claim a state for intentional infliction of emotional distress, because seeing Sweetie's dead body was enough. That's kind of where you were getting. Yeah. So the cops are saying, county, no, you got to be there and see me shoot it. You can say, no, the fact that I came out shortly thereafter and I saw Sweetie's dead body was enough to cause me emotional distress. Okay. I was
gonna say on a personal note, my grandfather, when he arrived home one day and saw my uncle dead on his floor, it was disturbing and it was distressing to him. So I can only imagine that arriving and seeing your dog or something like that. I mean, obviously it's not his own son, but yeah, I think yes. My answer is yes.
So now,
my answer is yes.
The question is, do you have to be present in order to recover? Or if you come upon the dead dog, as in this case, shortly thereafter, and find him shot and dead, can you bring your claim before the jury and not it dismissed on summary judgment?
I think he makes a reasonable argument, and I think it's worth hearing. Yeah.
Okay. So, all right. On appeal,
let's hear it.
Hold on. Buchanan does not challenge the general proposition stated in a case, M&M, and it was a minor. In the general proposition in Florida that in order to state a claim for intentional infliction of emotional distress based on his own emotional distress, a plaintiff must be present when the alleged extreme and outrageous conduct is directed towards a third party. Okay, so the general proposition is you've got to be there. And you've got to see it. All right, hold on. In M&M, the court, this is a different case, the court dismissed the parent's complaint for intentional infliction of emotional distress because they were not present when the admitted offensive treatment of their daughter occurred.
Okay.
So the daughter was mistreated, and in this case they didn't get into it, but it was pretty extreme. but the parents didn't witness it. So the parents could not bring their claim for intentional infliction of emotional distress based on the conduct to the third party, their daughter. You with me so far?
I think so. So
Your
the
your
emotional
kids,
distress to the
your
daughter
kids,
couldn't be.
something happens to your kids at school, you don't see it.
Yep.
You can't bring a claim for intentional infliction of emotional distress.
On myself.
Your damages for you.
My
You suffered
damages.
emotional
Right.
damages because I heard my daughter
Because
got
I heard my
attacked,
daughter have.
maybe
Yeah.
sexually abused,
Okay.
whatever.
Right.
Okay.
Okay.
That's the general
Now I
proposition.
understand.
All right.
Okay.
However, so that's the county's position.
I had a
Buchanan,
feeling this is about to get good.
well, Buchanan contends that he in fact was not present when Sweetie was shot and killed, is not dispositive of my claim, meaning that doesn't matter
It doesn't matter.
because Williams established an exception to the presence requirement
Uh-oh.
involving conduct to dead bodies.
Interesting. Interesting.
All
Okay.
right. All right. So there's
Okay.
an exception.
So we've got two precedents in
One,
collision with each
you
other.
have to be present.
You got to be present to win.
Two,
Yeah.
you don't have to be present if we're talking about a dead body.
Interesting.
I will continue. Hold that
That's
thought.
what we are. Yeah. Okay. Okay.
In Williams, officers in the city of Mineola Police Department, which is Florida somewhere, never heard of it, but it is Florida.
All these-
They showed a videotape and photograph of the minor child's autopsy to people outside the police department. The minor's mother and sister sued the police department and the officers in the county and so forth, alleging a claim for intentional infliction of emotional distress based on the display of the pictures.
Mm.
Okay, so what do you think happened with that one? So this one here,
That's the Williams one? That's the Williams case?
The sister and mother were not there when the police officers showed photographs to someone outside the police department. So the general rule is you have to observe it. In this case, they weren't there. Do you think that on the autopsy photos from their brother?
Did they release those to the public?
It doesn't say who they showed.
Or was okay? I'm just trying to
friends.
think. Did they see them and then go, "Oh my goodness, these are everywhere"?
They showed them to other people other than the police department.
Okay. I don't know. That seems to be irrelevant to me.
Just so you know, the judge at the court level dismissed the case, granted summary judgment for the county and the police.
Okay.
General rule says you have to be present.
Yeah.
What did the 5th District Court of Appeal rule?
I don't know. None of these are going the way I think.
The summary judgment granted in favor of the defendants on the claim of intentional or reckless infliction of emotional distress can lie for outrageous conduct involving pictures of the dead body of the plaintiff's spouse, child, sibling, parent, even though the plaintiff was not present when the pictures were displayed.
Okay.
So they said,
does that narrow it? Sorry.
100%.
It narrows it to the immediate family.
Yes.
Basically. So the dog wouldn't be included.
I didn't say that.
Okay, I don't know.
I did not say that.
You're tricking me now. I don't know which way this is going to go.
The court reasons that in situations involving a dead body, our society shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one.
Okay.
Ooh, a loved one. I love Millie.
Oh, no. Okay. Okay, the plot thickens.
All right.
Okay.
And the court explained that the plaintiffs can maintain their action for intentional infliction of emotional distress when it's a dead body of a loved one. All right. So the 5th District said, nope, sister and mother did not need to be there
Mm,
when in a
okay.
situation like this. So
And
yes, they
that's the
narrowed it,
precedent.
but there's an
Yeah,
exception.
the loved one.
Okie dokie. So
Language is so
now, hold on.
important.
Now
Language
where
is
are
so
you?
important. Language is so important. All right. I think that, yeah, I think I'm on the place where, given that exception, that precedent, I think there's going to be enough room where the judge, the appellate court will say, yeah, hear it.
Okay. Drum roll, please.
Yes. Hold on a minute. I've got it here somewhere. It's in here. Oh, drum. Oh, I have rim shot. That's
All
not the
right,
same
let's
thing.
move on. I should have had you get the drum roll ready. That was my
Yeah,
fault. All right,
that's all
so
right.
the
Sorry.
court's holding, which means ruling, in law we call it what's the holding of the court says. We find Buchanan's, that's the father's argument, that the exception to the presence requirement that's set forth in Williams applies to the facts at hand,
Ooh,
unpersuasive.
unpersuasively.
Yeah, Buchanan cites to no case extending the holding of Williams to a plaintiff's subsequent sighting of the body of a deceased pet after the
Mm.
complaint of outrageous acts or conduct have already occurred. And we are unable to do so here.
Oh, wow. All
Now,
right,
here's the
then.
sad part. And this, I
Yeah.
think we may have talked about this.
Can I ask you a question before you move
Yeah,
on?
you can. Yeah.
What if he had security camera footage and then was able to see it happen? Or like, oh my goodness, I saw that on the reviewing my security cameras, and then he sees it. He wasn't
That
physically present,
That
but
is
he
a
did
very good
witness it.
question. In the case that we had talked about, my case where the guy rammed the gate,
Right. Okay.
he had security footage.
Yes.
And it was
Right.
entered into the court, and the jury watched it.
Mm-hmm.
Yeah, you're not present.
Oh, it's so technical. Okay. Interesting.
But that's a heck of
Wow.
that's a good question, and I have a real life example. My trial.
Yeah, you do. Yeah.
Oh, and by the
Yeah.
way, I
Okay.
won. Yeah, we won.
Yeah.
So anyway,
Of course you did, Paul.
and here,
Yeah, good job.
and here's the kicker, and this is and I'll talk about it, but underpinning our conclusion is the well-established principle in Florida's jurisprudence, the law,
Mm-hmm.
viewing animals as personal property, despite the
Oh,
uncontrovertible deep attachment owners feel toward their domestic pets.
okay.
And we talked about that
That's
before.
valid.
While a dog may be considered by many to be a member of the family, under Florida law, animals are considered to be personal property.
Mm. Yeah, I mean that's valid, that's fact, that's legal. It does not feel good, I know.
Right.
But it is the law. It's interesting. It's
Now,
really interesting.
hold on. Now, there's another little exception.
Oh no.
This case is over, but
Okay,
there was
okay.
another case, and it's called Laporte, where the Florida Supreme Court held that an action for the willful and malicious killing of a dog, its owner's damages were not limited to the fair market value of the dog, which, your personal property, but properly included the element of the owner's mental suffering, anguish, and so forth, and said in reaching its conclusion, because the defendant's act in killing the dog, I guess the guy threw a trash can at the dog and killed it, was malicious and demonstrated an extreme indifference to the plaintiff's rights.
Oh,
So again, you
but
got,
you must be present to win.
and it has to be malicious.
Okay. Yeah.
Right.
Yeah, right. And that's why I think
And
that's why
say
I was
that
saying
because
that the officers.
you see
Sorry.
someone speeding down the road, your dog runs out in front of it and gets killed, in my opinion, you're going to get the fair market value of your dog at best. Now, they're going to argue your dog should have been on a leash and shouldn't have been in the road and so forth. But I don't think you're going to be able to get mental pain and suffering because even, speeding down the road under the law is not malicious.
And I think that that's also where my mind was at when I was asking the questions about the officer being in the line of his duty. You know,
I do. Right.
it's not
And
necessarily malicious, as opposed to like he jumped the fence in pursuit of someone and then, oh crap,
yeah,
here's a
but like I
dog.
said
Like,
though, that kind of really that wasn't it. But in
okay,
Laporte, the owner, it was a woman. She was present when her boyfriend picked up the garbage can and killed the
beat the
dog.
dog.
Yeah.
Whoa!
So,
Whoa!
at some point, you get little exceptions. An
That's
example,
good. There's some hope
unfortunately,
out
there was a case where the guy threw the dog out of the window on I-4. I don't know if you
there.
remember
Oh,
that.
bro.
So
Yeah, I actually kind of do now that you mention it.
the
Yeah,
courts,
vaguely.
they tend to get it right. And if you're going to do something like that, then you may very well be held accountable for your actions. So
Yeah,
anyway,
yeah. Way to
I
bring us
just
down.
I thought that was
Jeez.
interesting. Well, we get calls. We get
Yeah,
calls
yeah, yeah.
where like a veterinarian. We've got a call, and I think we might have done
Like a
a
malpractice.
yeah.
Ooh.
And we might have
Ooh.
done a podcast on this, but the bottom line is the vet, which is what the vet did, offered money on the value of the dog, and the people, and these were I believe it was South Tampa people. They said,
Mm.
no way, this was our loved one, our pet,
Mm-hmm.
and it went to the Supreme Court, and they said no.
Mm. Mm.
Animals are property, and you get the value of your property.
I think that's an important distinction to uphold, with certain exceptions, like that one case where like malicious,
Well, that's just it. Exactly.
that's different. Yeah,
It is.
yeah.
Well, I'll make no mistake though. If the girl had not been present when the guy smashes her dog with a garbage can,
Mm.
not been able to bring a claim for intentional infliction of emotional distress. But
Right,
because
but
she witnessed it, the Supreme Court says that's a narrow exception. We'll go with it.
malicious destruction of property is also a thing too, though, right?
Well,
Like, isn't that
no,
sort of
you would if
no?
I come in and burn your house to the ground,
I mean, you're going to cover the
you're not
house, not the
going to
emotional
you're
part.
not going to. Well, I'm just telling you, it ain't going to. Well, I take that back. Remember, on intentional infliction of emotional distress, it has to be outrageous and extreme conduct. Certainly, if I came in and
Okay,
burned your house to the ground, that's going to be
that would
outrageous
probably
and
work.
extreme
Yeah,
conduct.
that's kind of
And the
outrageous.
courts even say it has to be enough where society would say outrageous.
Okay, so on that, I don't want to drag it on too much more because,
Right.
like, you've done a great job. This is a great topic. I love it. I'm very interested. But road rage.
Well, again, road rage would be a battery. If you ram my car, you have a count for battery.
Is that because I'm in it?
Yeah, yeah.
Okay. I've
Battery
seen some
being
road rage
the
videos lately
intentional
that are,
striking, of the person. So yeah, if you ram my car, you would have a battery
hmm,
count. And
yeah.
remember,
Okay.
in your typical count, you get damages for the loss of the enjoyment of life and embarrassment and mental pain and
Okay.
suffering, inconvenience. So it's kind of wrapped
Okay.
up all in there. What people think are pain and suffering damages,
Yeah.
there's a long list of
There's a lot. Okay.
mental anguish. So all that would be incorporated. So you really wouldn't
Interesting.
have to bring a claim for intentional infliction of emotional distress. Um,
Okay.
you could,
Okay.
you could, but it would be also encompassed in the battery count.
And it would probably, like you said, have to be outrageous. Like, I mean, I've some of the
If
videos I've seen lately of road rage.
someone is ramming your car, that would be outrageous.
I saw this one guy. It was like trying to run this motorcycle off, and then the motorcycle guy decides, I'm just going to get on the shoulder, turn around, and go the other way. So this guy turns around and drives off road after him, and like, I mean, it was crazy wild. So anyway,
Everybody's seen that. It's real crazy. All right, well that's it. It's
yeah,
what, November the 8th.
it is. It is.
Ellie is still asleep. And
Yeah.
I'm glad we kind of got back to the topic of the law versus some of the other things.
Yeah. The other stuff. Yeah. My nephew's wedding anniversary is this weekend. This is the 11th or next week, early next week. He's a new dad, so God bless him out there. Shout out to him.
There you
Hey,
go.
Johnny.
Give him a shout out.
Yeah,
What's his name?
his name's Johnny, Jonathan Bates. He's a good
Jonathan
guy.
Bates. Happy anniversary, you said?
Yeah, man.
All
Yeah,
right. Well, happy anniversary from Live Feed Reed.
that's right. Yeah,
All right, Jason, get us out of here.
you got it. You got it.
Reed and Reed, it's like having a lawyer in the family.